Good afternoon or good morning to anyone in the western part of the country. My name is Cameron Hamrick, and on behalf of our distinguished panel, I would like to thank everyone for joining us as we discuss a very important set of developments for federal contractors and subcontractors. But first, let me introduce our panel. From our Chicago office, we have Kim Leffert and Maritoni Kane. Kim and Maritoni are both litigators and corporate advisors with over 20 years of experience each. Their practice is primarily focused on labor and employment litigation and counseling on behalf of employers. They both provide clients counseling on the numerous laws at issue in the new Fair Pay and Safe Workplaces regulations, including statutes that go by the following acronyms, in which you'll come to know better by the end of this webinar: the NLRA, FLSA, the ADA, the FMLA, the ADEA, and the list goes on. And from our Washington office, we have David Dowd. David is a very experienced and successful government contract specialist with expertise in a wide variety of procurement issues, and he is also a very accomplished litigator. And finally, I also practice in the D.C. office and focus on a wide array of government contract matters. Before we begin, I have just a couple of housekeeping announcements. First, as we go along, we hope that you will ask questions by using the Q&A panel on the right side of your screen, and we will make every effort to answer questions during or toward the end of the webinar. However, if we are unable to answer your question during the presentation, we will follow up with you after the webinar has ended. Second, with respect to CLE credit, while approval is pending, we will be providing an alphanumeric code at the end of the presentation. In order to receive CLE credit, participants must record this code on the virtual sign-in sheet that was emailed to you with the login instructions for today's program. And with that, let's get started. Slide 3. This slide shows at a very high level the topics we plan to address today, and we will spend the most time on the third topic, the new Federal Acquisition Regulation, or FAR, responsibility criteria and associated aspects of the Department of Labor's guidance, because the FAR criteria and guidance establish a sprawling and often complicated responsibility system that departs in significant ways from the current version of the FAR. Okay, slide 4. On August 25 of this year, the Federal Acquisition Regulatory Council, or FAR Council, issued its final rule implementing Executive Order 13673, entitled Fair Pay and Safe Workplaces. And on that same date, the Department of Labor issued its final guidance to assist the FAR Council and contracting agencies in implementing the executive order. The new rule and guidance present a powerful mix of government contracts law and labor law. For example, the rule requires covered government contractors and subcontractors to disclose violations of 14 federal labor laws and certain equivalent state laws. The rule is very broad in this respect. Labor law violations apply to a company's private sector work as well as its government contracts. And we will discuss these disclosure rules and labor laws in just a bit. But before getting into the details, I want to reemphasize that the new rule and guidance represent a very significant development for federal contractors and subcontractors. This complex system will prove extraordinarily costly for both businesses and the government, but mostly businesses, approaching a total of $500 million in the first year alone based on the government's own estimate, and a 10-year total of over $4 billion. This is a staggering amount. The primary focus of the new FAR rule and the Department of Labor guidance is on contractor and subcontractor responsibility based on various labor laws. Responsibility is crucial because the government will only conduct business with responsible contractors. The FAR defines a responsible prospective contractor as a contractor that meets the standards in FAR 9.104, which include, for example, having adequate financial resources to perform the contract and having a satisfactory record of integrity and business ethics. Those determinations have traditionally been made prior to awarding a prime contract or executing a subcontract. Yet the new FAR rule requires covered contractors and subcontractors to submit semi-annual labor law updates after award that can trigger adverse actions such as termination of a contract. In addition, the new system is not limited to responsibility determinations. Even though the executive order does not specifically mention past performance, the new FAR rule requires that past performance evaluations for covered contracts must include consideration of a contractor's labor law violation information, as well as the extent to which the prime contractor addressed labor law violations by its subcontractors. This likely will lead to more bid protests, as we will discuss a little later. In addition to an increase in protests, the new system will likely increase litigation for contractors, including litigation with employees as well as with subcontractors. And all of the submissions of information to the government required by the new FAR rule increase contractors' exposure to alleged violations under the Civil False Claims Act. Okay, next. I should add that some members of Congress appear to recognize the many burdens and risks associated with the new system because legislation has been introduced seeking to diminish the impact of the new system or to do away with it altogether. And I should also note that less than 2 weeks ago, 3 contractor associations filed a lawsuit in the Eastern District of Texas against various government officials to have the executive order and the new FAR rule and Department of Labor guidance declared unlawful based on various grounds. The complaint includes, among other claims, a count alleging that the executive order, the FAR rule, and guidance are preempted by and otherwise violate language in the 14 federal labor laws listed in the executive order. Other suits may be filed, and we will keep our eyes on this litigation. And I'm now going to turn it over to Kim.
Thank you, Cameron. I did see that the lawsuit that was filed, they also asked for a temporary injunction, and the hearing on that injunction is going to be on Friday. So we may hear something about this very soon. To give you a little background, President Obama issued the executive order over 2 years ago in July of 2014. And the order's justification rests on promoting economy and efficiency in procurement by contracting with responsible sources who comply with labor laws. And the order asserts that contractors that consistently adhere to labor laws are more likely to have workplace practices that enhance productivity and increase the likelihood of timely, predictable, and satisfactory delivery of goods and services to the government. And even assuming that this is true, the government's own huge estimate of costs associated with this new rule raised important question about whether enhanced productivity and other alleged benefits will justify these elaborate new requirements. The order states that contractors who are bidding for a contract must report violations of these labor laws during the bidding process and periodically post-award. So this is a very new issue and a new thing that comes up and that contractors really previously had not had to do, especially post-award. So let's discuss what those 14 labor laws are. Thank you. And they're listed here on this slide. The first is the Fair Labor Standards Act, the FLSA. This is the law that requires employers to pay wages on a regular basis and to provide for overtime for individuals who do not fall within one of the exemptions. The next is the Occupational Safety and Health Act, known as OSHA, which provides that workers be given a safe workplace. The Migrant and Seasonal Agricultural Worker Protection Act, this of course provides for safe workplaces for migrant and seasonal agricultural workers. The National Labor Relations Act, the NLRA, which specifically focuses on employees who are represented by unions, but the NLRA the National Labor Relations Board takes a position that many of its rules might apply to even workers who are not currently represented by unions. the Family and Medical Leave Act, the FMLA, which provides for leave for individuals in certain workplaces because of their own health conditions or the conditions of a family member. Title VII of the Civil Rights Act of 1964, which prohibits discrimination on the basis of sex, race, national origin, and religion. The Age Discrimination in Employment Act, ADEA, which prohibits discrimination on the basis of age. The Davis-Bacon Act. This is a law that requires workers on federal construction projects be paid a set minimum wages. That is, that workers must be paid no less than locally prevailing wages and fringe benefits paid on similar projects, and the Department of Labor determines the prevailing wage. Similarly, the McNamara-O'Hara Service Contracts Act is a similar prevailing wage law, but for workers who work on service contracts, such as janitors who provide services in government buildings. Section 503 of the Rehabilitation Act prohibits discrimination on the basis of disability for federal workers, and the Americans with Disabilities Act, which I skipped, prohibits discrimination on the basis of disability for workers in private workplaces, all other workers. Finally, going down to Executive Order 11246, this was enacted in the 60s and is the executive order that government contractors are all very familiar with. This is the one that requires preparing an affirmative action plan. And then Executive Order 13658, this was an executive order enacted by President Obama, which establishes a minimum wage for contractors. Next slide. The guidance also says that not only are these the labor laws, but there will also be, the Department of Labor will also identify equivalent state laws. To date, the only equivalent state law that's been identified by the Department of Labor are OSHA-approved state plans, so the state OSHA plans. But the guidance states that the Department of Labor will sometime in the future issue further guidance identifying the other equivalent state laws. One can only imagine what those to-be-identified state laws might be. One would presume that they are the equivalents of the laws that I've just of the federal laws that I've just listed to you, including laws about equal opportunity and wage payment, wage and hour laws, laws requiring breaks and meal periods, laws requiring minimum wage, all of those many, many laws that the states have enacted. Cameron?
Thanks, Kim. You know, I have steeped myself in the FAR ruling guidance and the commentary, and it takes a long time to get through these documents. And it's apparent to me that the complications, risks, and concerns associated with the new FAR ruling guidance can be seen just in the length of the Federal Register publications. The FAR rule, including associated commentary, is almost 90 pages long, and that's 3 columns of single-spaced text on every page. And the Labor Department's guidance and commentary are over 110 pages long. These publications include substantial efforts, not always successful, to respond to some of the tidal wave of comments submitted in response to the proposed ruling guidance. Contractors should seriously consider reviewing these publications in their entirety, because while we do not agree with all of the government's responses and comments, they represent the government's current position on the rule and the guidance and help answer questions raised by some of the complex new provisions. I should add that unlike the executive order and the new FAR rule, the guidance does not bind private parties or agency officials and is not a regulation. However, the new FAR rule, which of course is a regulation, incorporates parts of the guidance. The new FAR rule is lengthy and includes many moving parts. Again, the primary focus of the executive order is on assessing the responsibility of certain contractors and subcontractors based on the listed labor laws. And consistent with this focus, the FAR rule adds provisions to FAR subpart 9.1, which deals with determining whether prospective contractors and subcontractors are responsible. For prime contractor responsibility assessments, a new provision at FAR 9.1 indicates that if an offeror for a contract has indicated in response to a new clause that it has had a labor law violation within the applicable time period, the contracting officer must follow the procedures at a new FAR subpart 22.20. Similarly, a new FAR 9.1 provision refers prime contractors to that same new subpart 22.20 for subcontractor responsibility assessments. And FAR subpart 22.20 is where many of the complications and risks appear. That subpart includes key definitions, including definitions of administrative merits determination, arbitral award or decision, and civil judgment. These definitions are the foundation of the labor law violations that have to be disclosed in connection with responsibility determinations, and it is therefore important that contractors and subcontractors have a clear understanding of these definitions, and I'm now going to let Maritoni discuss these definitions further.
Thanks, Cameron. As you indicated, FAR subpart 22.20 addresses the types of violations which contractors need to disclose. And as you identified, there are 3 categories of relevant violations which need to be disclosed. I'm going to discuss the definitions of each of these in the upcoming slides, but to give you some background, and as others have hinted to, when the definitions were published, there were many groups who submitted comments about the definitions. On the one hand, industry groups argued that the definitions were too broad and included too many things to disclose. And on the other hand, employee and union advocacy groups argued the definitions were too narrow or just fine as written. After all the comments were reviewed, the definitions largely remained unchanged. So what is the definition of an administrative merits determination? An administrative merits determination includes notices or findings, whether final or subject to appeal or further review, issued by an enforcement agency following an investigation that indicates that the contractor or subcontractor violated any provision of the labor laws. An enforcement agency, as referenced in the definition, includes the Department of Labor and all of its agencies, such as OSHA, the Occupational Health and Safety Administration, the WHD, the Wage and Hour Division, OFCCP, Office of Federal Contract Compliance Programs, OSHRC, Occupational Safety and Health Review Commission, as well as the EEOC, Equal Employment Opportunity Commission, and the NLRB, National Labor Relations Board. A lot of acronyms there. So there are 3 takeaways that I want to give you with regard to this definition. First, the notices or findings are subject to appeal or further review. This was one of the definitions, or the inclusion of this was highly commented on as well. Therefore, non-final and appealable means that decisions a contractor may need to, the decisions that a contractor needs to report on might be findings or orders where they're in the midst of challenging or can still challenge. Many commentators called this the guilty until proven innocent determinations. So this means that an agency can deny an offeror a contract award based on a decision that might be later invalidated or overturned, which is really quite significant. Next takeaway with regard to administrative merits determinations is that the list provided in the Department of Labor guidance is exhaustive. There are 7 categories of administrative merits determinations, and if what is listed is not, if what you have is not listed in the guidance, it will not count as an administrative merits determination. So the 7 categories include wage and hour forms and letters, OSHA citations and notices, OFCCP show cause notices, EEOC letters and actions, NLRB complaints, complaints filed on or behalf of enforcement agencies, and orders or findings from ALJs or enforcement agencies. Some comments of note with regard to some of these categories include the fact that OSHA citations include notices of failure to abate. EEOC letters and actions do not include charges, but do include reasonable cause determinations. And NLRB complaints do not include unfair labor practice charges. In addition to these 7 categories, guidance on an 8th category is expected to be published later on by the Department of Labor addressing notices and findings by state enforcement agencies. The third point I wanted to make is that with regard to settlements, several labor and agency and worker advocacy groups urge the Department of Labor to define administrative merits determinations to include settlements reached with an enforcement agency. The Department of Labor on this issue actually held its ground that settlements are not administrative merits determinations and need not be disclosed. The Department of Labor didn't want the inclusion of settlements in this definition to serve as a disincentive to settlements because they found that settlements were ideal outcomes for both employers and employees, as well as efficient outcomes. Next are civil judgments, and they are any judgment or order by any federal or state court in which the court determined that the contractor or subcontractor violated any provision of the labor laws or enjoined or restrained the contractor or subcontractor from violating any provision of the labor laws. This includes judgments or orders in actions brought by enforcement agencies or private parties. It also includes orders or judgments reached by way of jury trial, bench trial, or motion, and it actually includes summary judgment or partially summary judgment orders. Similar to the administrative merits determinations, this includes judgments or orders that are not final or that are subject to appeal. And the guidelines clarified that this does not include a private settlement where a lawsuit is dismissed by a court without any judgment being entered. This also includes offers of judgment under Federal Rule 68. And just when you thought you might be getting it, for clarification, orders by administrative law judges are not civil judgments, they are administrative merits determinations. So next is arbitral awards or decisions. Now, many employers prefer that their employees arbitrate any disputes that they may have with them because the arbitration can be confidential. Now here, arbitral decisions include awards or orders by an arbitrator or an arbitral panel, again, where they've determined that the contractor violated any provision of the law or enjoined or restrained them from violating any provision of the labor law. And significantly, this includes awards and decisions even if the arbitral proceedings were private or confidential. Again, consistent with the other categories of violations, it includes awards or orders that are not final or are subject to being confirmed, modified, or vacated by a court. But for clarification, it does not include an arbitrator's decision finding only a collective bargaining agreement violation. So with regard to all of these violations which must be disclosed, whether there is a successive violation arising from the same underlying violation and whether that needs to be disclosed depends upon the holding. So if a violation is later reinstated, upheld, affirmed, or remanded, the recent decision needs to be disclosed. In addition, contractors need to provide any updates to correct any incorrect information. And with that, I'm going to pass the discussion to Cameron, who's going to talk about who is a covered primary contractor and subcontractor.
Thanks, Maritoni. And actually, we've got a question which I'll read part of, which is a perfect segue into what I'm going to talk about. And the question is, does the executive order apply to GSA schedule holders? By its terms, it doesn't appear to. I can tell you, as I said, I've combed through the lengthy commentary in both the guidance and the final rule, and I do not recall references to the GSA schedule. But here's what the plain language of the rule says about who is covered. It says that this is with respect to the disclosure obligations for responsibility purposes. Those obligations apply to, at the prime contract level, offerors on solicitations estimated to exceed $500,000. That does not exempt procurements for commercial items or for COTS items. Those offerors must represent whether in the past 3 years any labor law violations have been rendered against them, and as we will discuss in just a few minutes, certain requirements apply after award to prime contractors under those contracts. In addition, a covered subcontractor, for purposes of labor law disclosures, is a prospective or actual subcontractor where the estimated value of the subcontract is, like at the prime contract level, $500,000, but it is not for commercially available off-the-shelf or COTS items. So for subcontracts, COTS are carved out, but they are not carved out for prime contract purposes. Okay. Also, certain parts of the new rule, the responsibility provisions, will be phased in as reflected in this slide, which is really self-explanatory. So to save time, I'm not going to dwell on this slide. Let's discuss the mechanics of the prime contract pre-award disclosures. If an offeror represents that it has had a labor law violation within the specified period, and the contracting officer has initiated a responsibility determination, which would be triggered because the offeror is the apparent contract awardee, then the offeror has to disclose within a government database known as System for Award Management, or SAM, the following information: the labor law violated, the case number or other unique identification number, the date rendered, and the name of the court, arbitrator, agency, board, or commission that rendered the decision. And this information will be publicly available in what's known as the Federal Awardee Performance and Integrity Information System, or FAPIS, which is another government database. Also, thankfully, the offeror can provide additional information it deems necessary to demonstrate its responsibility, including mitigating factors and remedial measures. For example, offerors can provide explanatory text and can upload documents. And this information will not be made public unless the contractor wants it to be public. And I'm now going to turn it back to Maritoni to discuss this additional information that companies can provide.
Thanks. So a company's initial reaction might be, I'm not disclosing anything else. I didn't want to disclose anything in the first place, and I'm not going to disclose anything else now. But based on the guidance, it benefits a contractor to disclose mitigating factors. And what I'm going to go focus on is what some of those mitigating factors are. The ones which carry the most weight are the first two I'm going to discuss. The first is, did the contractor take steps to correct the violation? Did they engage in remediation? So did the contractor assume responsibility to correct the violation? So did they abate a workplace hazard, or, for example, did they pay a worker back wages owed? The next one is, did the contractor take steps to improve compliance? So did the contractor implement remediation on an enterprise level, or go beyond what's minimally required by the law? Also, at what stage is the violation? Is it non-final or appealable? Those type of determinations will be given less weight. Was the violation committed during the performance of a federal contract or not? In other words, did the violation precede the employer being a federal contractor, or did it involve another division of the employer not engaged in activities or work related to the federal contract? Was it a first violation, or has there only been one violation? The guidance provides that in most cases, a single violation will not give rise to an adverse finding. Did the violation involve one employee out of an employee pool of hundreds or thousands? Again, context is important. Does the contractor have safety and health or compliance programs? So do they have groups where employees are empowered to raise concerns? Have there been recent legal or regulatory changes related to the violation at issue? For those of you that practice in the employment space, we know that in recent years, the EEOC and the NLRB have been very aggressive with regard to their interpretation of what have been long-lasting existing rules and regulations. So this might be an area where a contractor or an employer can rely on an old interpretation. Also, did the contractor act in good faith and have reasonable grounds for believing it was not violating the law? So did the contractor rely on advice from a responsible official that what it was doing okay? What comes to mind when I read this is if you're an employer and let's say in the FLSA, the wage and hour world, you had an audit by the Department of Labor and they found that your practices or your classification employees was proper and you have continued to treat or classify employees the same way, but that is now deemed to be a violation, you can state as one of the mitigating factors that you had a good faith belief of what you were doing. Also, has there been a significant period of compliance before the violation? Again, have the violations been few and far between? So what happens after, so actually I want to go back. So, even if you're reluctant to disclose any information, for employers, I recommend you ask yourself these questions to determine whether any favorable mitigating factors exist, which you might as well take credit for. But as you can see, it really takes a lot of analysis, and it may take a lot of advocacy to determine what information, what mitigating factors, and the manner in which you're going to present them to the individuals responsible for making decisions concerning your contract. So what happens after all the disclosures? First, an agency labor compliance advisor performs a pre-assessment of a contractor's labor law violations. So the agency labor compliance advisor focuses on analysis and advice. The second step involves a contracting officer's responsibility determination. So the contracting officer is the ultimate decision maker on whether the contractor has a satisfactory record of integrity and business ethics. I'm going to talk about the process that the agency labor compliance advisors go through to make their assessment and how they will classify violations. And then David will talk about the qualifications of the compliance advisors and contracting officers, about further steps in the pre-assessment process, and share some insights about how he thinks this will all actually pan out in the future. So let's talk about the labor compliance advisors process. Step one in a three-step process involves the compliance advisor monitoring the SAM and the FAPSIS for violations and determining whether they're serious, repeated, willful, and or pervasive. And I'll get into these classifications more specifically on the next slide. But the second step of the process involves the agency labor compliance advisor weighing any violation in light of the totality of circumstances. And that again includes the severity of the violations, the size of the contractor, and any mitigating factors, which again look at whether there's timely remediation, what the history of compliance is, and the adoption of any preventable measures. Then, in the third step, the labor compliance advisor makes a recommendation to the contracting officer. And again, David will talk more details about these recommendations, but with regard to the classifications, there are several classifications, and I'll be covering a lot of information fairly quickly, but I encourage you to just listen and absorb the big picture. If you need to check out something specifically at a later date, there are tables of examples of each of these violations in the appendices to the Department of Labor guidelines, which you can reference. So with regard to serious violations, the guidelines provide an exhaustive list, and they include an OSHA violation that was designated as serious as well. And then for all other labor violations, it would be deemed a serious violation if it involved one of 9 various facts. The examples here include the violation affected at least 10 workers or affected employees composed 25% or more of the workforce at the work site. Fines and penalties of at least $5,500 were assessed, back wages of at least $10,000 were due, or the contractor engaged in retaliation. Others examples of what can be found to constitute serious violations, which I didn't include strictly due to space on the slide, include contractor's conduct caused or contributed to the death or serious injury of one or more workers, a contractor engaged in a pattern or practice of discrimination or systemic discrimination, or a contractor breached the material terms of any agreement or settlement with an enforcement agency or violated a court order or arbitral award. And the guidelines provide further guidance as to what the various criteria are. With regard to repeated violations, a violation will be deemed repeated if there is an OSHA violation was designated as repeated as well. And again, for all other labor violations, if the violation is the same as or substantially similar to one or more other violations of the labor laws. So for a repeated violation, there is a look-back period of 3 years. The prior violation must have been uncontested or adjudicated, but the second one does not have to be. And to be found to be a repeated violation, it can include any 2 violations, even if they arise under different statutes, if other violations involve the same protected status, so for example, sex, pregnancy, gender identity, and they have at least one of the following elements in common, which include the same employment practice or the same work site. With regard to willful violations, the guidance discusses situations under specific labor laws which constitute willful violations. And you can see the examples I have set forth here, and basically under the various statutes, they involve findings of willful violations or awarding of liquidated or punitive damages. They also include a criteria where if it's ascertainable from the findings that the contractor knew its conduct was prohibited or showed reckless disregard for or acted with plain indifference to whether its conduct was prohibited by labor laws. And with regard to this criteria, the key question is, did the contractor make sufficient efforts to learn or understand whether it was complying with the law? Therefore, ignorance of the law is not a defense to a willful classification. With regard to pervasive violations, a violation will be classified as pervasive if there is a pattern of serious and or willful violations, continuing violations, or numerous violations. Again, with regard to the item of numerous violations, the advisor will look at the size of the contractor, and there is a difference if there are numerous violations and the work pool is made up of 25 employees versus a workforce made up of 3,000 employees. A couple things to keep in mind is that a single violation may satisfy the criteria of more than one classification. Therefore, a violation can be classified as both serious and repeated. And multiple violations together can be classified as pervasive. A key is that if a labor law decision or a portion thereof is reversed or vacated, so it's no longer serious, repeated, willful, or pervasive, the violation can no longer be classified as such. So if there was an OSHA citation that was classified as serious, which is later redesignated as other than serious, it can no longer be classified as a serious violation. I pass that on to David now.
Thanks, Mayor Tony. Contracting officer responsibility determinations. And in that light, I thought it would be helpful to discuss current practice and compare it to what's going to happen under the new rule. First of all, in terms of current practice, and Cameron mentioned this earlier, but the FAR refers to prospective contractors. There's been a requirement in the Federal Acquisition Regulation for 3 decades or more than 3 decades now, and there was a requirement under prior regulations that contracting officers had to determine prior to awarding a contract that the contractor to whom the contract would be awarded is a responsible entity. That means, generally speaking, a contractor with a satisfactory record of business ethics and integrity and the capability to perform the contract at issue. Under the current FAR, this determination is made at one time and one time only, and that is prior to the award of the contract at issue. The determination that is made is specific to the particular contract. It is not a general determination of the contractor's capability to perform or of its record of business ethics and integrity. Now, historically, when contracting officers made this determination, they relied on a certification from contractors that's found in the Federal Acquisition Regulation. It's referred to as a certification of responsibility of contractor. The site is 52.209-5 in the FAR. In that certification, the contractor would provide information regarding convictions or judgments as to the violations of certain kinds of laws, mostly pertaining to government contracts, with a few additions, such as antitrust violations or commission of forgery or falsification of records. And the contractor also had to identify any outstanding tax liabilities. Now, many or most contractors would check no for almost all of those provisions. Contrast that with the discussion we've been having today with regard to labor law violations, and consider for yourself that many if not most contractors would check yes in terms of some form of labor law violation if it's a larger contractor. Another interesting aspect of the old rule, perhaps contrasting with the new one, is that FAR 52.209-5 stated toward the end that the regulation was not intended to require the development of a system of records for the contractor to be able to answer the question or the questions that were posed in that regulation. We're going to advise later in this discussion that it's a very different requirement than we have under the current new rule, the Fair Pay and Safe Workplace Act, which does require, in our view, the establishment of a complex system of records to answer the question. So in responsibility, contracting officers had broad discretion to make a call. They would consider financial resources, performance record, business record, ethics and integrity. They would consult FAPIS, which was referred to earlier. They were not required to consult with particular individuals. They were not required to follow the advice of particular individuals when they made that determination. And they would make that determination, as I mentioned, one time and prior to the government expenditure of any money on that contract with that contractor. So let's contrast that to the new rule. What the new rule requires is that the contracting officer specifically must consider labor law violations. That was not an express requirement prior to the promulgation of this rule. What does this now mean? Well, one violation alone, one labor law violation alone, the regulation provides, is not dispositive on the question of the contractor's responsibility, but it could be. Under the new rule, a contractor could have a satisfactory record of business ethics and integrity, a fine performance record, the resources to perform a contract, and yet have suffered some labor law violations on projects wholly unrelated to work for the government, and that contractor could be found not responsible and therefore ineligible for award of a government contract. One point I'd like to note on this is the advice that is coming from the ALCAs. There is nothing in the rule that requires the ALCA to have any particular labor law experience or competence. In promulgating the rule, the FAR Council noted that contracting officers most certainly do not have the capability to address labor law issues. So you have a situation where the contracting officer must consider and rely upon advice from an advisor who may or may not have the requisite degree of experience to address the question. Now, we've had experience with contracting officers having to rely on advisors. We see this regularly in government contracts with DCAA in the context of defense contracting, or with the Inspector General at the General Services Administration in the context of scheduled contracts. So contracting officers have some experience relying on advisors. It's just rare that they would have to basically follow the advice of the advisors. Now, the ALCAs are to make recommendations to the contracting officer. I've listed them here on slide 25. There are 5 categories of recommendations that are to be made. I think you can boil down to 3 flavors of recommendations. Looking at the top of the list, the contractor has a satisfactory record of business ethics and integrity, in which case the contractor can be found to be responsible. At the bottom of the list, the contractor clearly does not have that record due to the labor law violations and or lack of mitigation or remediation, and therefore should not be found eligible for the award of the government contract. And then you have the middle three categories, which contemplate that the contractor may be responsible, but in order to perform the contract, a certain type of agreement known as a labor compliance agreement is required. Essentially, the more severe the situation, the earlier that agreement will be required. Next slide. So just briefly, so what is the contracting officer then to do? The contracting officer must take the advice from the ALCA, must include in his or her file that report from the ALCA, decide whether to follow the advice given by the ALCA or not, must document in the file how that advice was followed or not, and then notify the contractor of its decision, whether the contractor is responsible, and if an LCA is required, with what agency the contractor should enter into that agreement. One point to consider here is a lot of this, like a lot of advice that contracting officers sometimes need to rely on, has to be timely provided. The rule contemplates the possibility that a contracting officer may not have been provided timely advice from the ALCA. In that context, the regulation says that the contracting officer should exercise his or her business judgment based on the available information and go ahead and make a decision. And I want to just note there as I say that the rule, as I pointed out earlier, contemplates that the contracting officer may well lack the expertise to make such a judgment. With that, I wanted to turn it to Kim to discuss the labor compliance agreement.
So the labor compliance agreement is actually entered into between a contractor or a subcontractor and the enforcement agency, which is one of those agencies with authority to enforce federal law, which, as Maritoni described before, means the EEOC, the NLRB, or the Department of Labor or its sub-agencies. And what they do is they address three items: appropriate remedial measures, such as the payment of back pay, compliance assistance, and third, steps to resolve issues to increase compliance with the labor laws, for example, implementing new safety and health measures, and other related matters. Now, this is kind of a new thing, but the commentary to the guidance likened these labor compliance agreements to conciliation agreements that these agencies sometimes enter into at the end of a period of litigation. For example, the EEOC, when it has found substantial evidence of discrimination and may enter into a conciliation agreement with an offending employer, saying you must do all of these things in order to avoid discriminating in the future. Here, these LCAs are being entered into by the enforcement agencies even before there's actual investigation by the enforcement agency of these problems, but it's because the ALCAs decide that these labor compliance agreements need to be entered into. Note that the procurement agency itself is not a party to the LCA. Also, another thing that is important is that the existence of the LCA will be noted in FAPIS, which means the existence will be public. Now, the enforcement agency has the discretion to make the LCA itself public, but at least amongst these laws, only the existence of the LCA will be noted in FAPIS. David?
Thank you. Just briefly, I wanted to talk about the requirements for post-award updates and assessments. Under the current rule, as I mentioned, responsibility is determined once at the outset before the award of a contract and not again after that. Under the new rule that we're discussing today, there is a requirement for periodic updates by the contractor with regard to disclosed labor law violations. Every 6 months, semi-annually, the contractor is to update in SAM any new information that's relevant in terms of labor law violations. The regulation says that if the SAM registration is less than 6 months old, that is considered evidence that it is updated and the requirement and the regulation for current, accurate, and complete information is met. I'll note that it says that it's evidence of that. It doesn't say it's conclusive on the point, so there's a bit of a wrinkle there in the regs. In terms of what a contractor should do in this regard, the requirement for a 6-month update could leave the contractor in a situation where information is a little bit stale, particularly in terms of mitigation measures that may be untaken. So a contractor may want to consider updating more frequently, particularly with regard to mitigation measures that can be included in the registration. The ALCAs are to review the information during the course of performance and provide updates to the contracting officer. The contracting officer should then consider that information with regard to potential actions that may be taken. The regulations contemplate that the kinds of actions that the contracting officer may take include such steps as termination of the contract or a decision not to exercise the contract option or requirement of execution of a labor compliance agreement of the type that Kim was just mentioning. And finally, the contracting officer may end up referring the matter over to the suspension and debarment official for appropriate action. So there's a wide range of actions that the contracting officer may take in response to new developments that occur post-award. And I'd like to note that one thing to keep in mind with this regulation, unlike others, is that it's a very fluid situation. Any given contractor will have dozens, if not hundreds, and possibly thousands of contracts that may be impacted by labor law violations, with dozens, if not hundreds, possibly even thousands of contracting officers reviewing those matters. Prime contractor assessments, very briefly. Currently, and again here I'd like to talk a little bit about the current practice in the new state. The current practice is that contractors must make determinations that the entities to whom they award subcontracts are responsible. That's an obligation that the prime contractor has, and there is very little guidance in the FAR in terms of how that determination should be made. There is no particular documentation requirement, though the current regulations note that the contractor may be asked for evidence of what it does in that regard. Many contractors look only to their immediate or first-tier subcontractors and don't consider downstream subcontractors in making responsibility determinations, and they tend to be very lightly documented. The new rule requires that the prime contractor is responsible for ensuring the responsibility of its subcontractors at all tiers. And again, that's all subcontractors where the subcontract exceeds $500,000 and is for something other than commercial off-the-shelf items or COTS. So what do the primes need to do? The prime contractor needs to ensure that the putative or the proposed subcontractor, both before award and after award on a semi-annual basis, provides the same type of information regarding labor law violations that we've been talking about with regard to the prime contractor. The regulation contemplates that that data will be provided directly to the Department of Labor, ideally in the form of a pre-award assessment that can then be shared with the prime contractor. Alternatively, if it's possible, the would-be subcontractor could check that there have been no labor law violations, which would make things obviously much easier in terms of how a prime contractor has to deal with it. But assuming that the subcontractor has some form of labor law violation, the expectation in the regulation is that subcontractor will consult with the Department of Labor and provide information to the prime contractor for the prime contractor to use in making its determination as to whether the subcontractor is responsible. Now, the regulation contemplates two wrinkles that I want to mention here. One possibility is that the Department of Labor takes the position that a labor compliance agreement is required and the subcontractor disagrees. The regulation contemplates that the prime contractor nonetheless can go ahead and make award to that subcontractor, even though the Department of Labor essentially is not on board, but the prime contractor has to document that finding and advise its contracting officer that it has made such a determination. That determination, of course, can be considered in the prime contractor's responsibility going forward. The second thing I want to mention is the rule contemplates, as I think will likely happen, that there may be circumstances where the Department of Labor input is not timely provided. The regulations contemplate that a subcontractor, upon asking the Department of Labor for feedback, will get that feedback within 3 business days. The regulation contemplates that there may be circumstances where the prime contractor doesn't have the information available from the subcontractor and has to go ahead and make that determination on its own. There, too, as was true at the prime contract level, the contractor has to make the determination in its business judgment based on the available information. A couple of practical issues to note very quickly. Because the prime contractor is accountable to the government for the responsibility of its subcontractors, and the subcontractor may be providing information semi-annually that reveals a new responsibility problem that may adversely reflect upon the prime contractors may seek to impose obligations on their subcontractors in the form of remedies that may be available to the prime contractor that would enable the prime contractor either to decline to use that subcontractor going forward, as the government does not exercise options, or possibly even to terminate that subcontractor for a lack of responsibility. That prospect would be a novel departure from the way most contractors have entered into agreements with their subcontractors. Typically, subcontract agreements do not allow for the prime contractor to terminate in many instances, including in instances where the responsibility of the subcontractor is at issue. Finally, I just would like to note in this regard, experience in terms of commercial item determinations that we've seen mostly on the defense side, because I think it bears noting in the fair pay context as well, and that is, under the Defense Federal Acquisition Regulation, there's a provision that contemplates that the prime contractor could make a determination as to whether or not items that are being provided to it qualify as commercial items under the FAR. The regulations call for the prime contractor to make that judgment, yet also note that this is a matter that could be considered by the government going forward in terms of reviewing the prime contractor's purchasing system or in determining whether or not costs should be reimbursable. I see an echo of that here in that there is an obligation being imposed on the prime contractor to make judgments without assistance in some instances, perhaps most instances, from the government, and yet the prime contractor could be held to account for something that is being provided or performed by another party that's beyond its control. And with that, we turn to Kim.
Okay. Thank you, David. So the executive order includes a paragraph entitled Paycheck Transparency that requires solicitations and contracts estimated to exceed $500,000 to require contractors in each pay period to provide individuals who perform work under the contract with certain information. In order to comply with the executive order's requirements for paycheck transparency, the guidance states that in each pay period, contractors and subcontractors must provide all persons providing work under the contract with a wage statement including the following information: the number of hours worked, overtime hours, rate of pay, and any additions or deductions from their pay, which is pretty standard for most payroll systems and pretty commonly provided. What's not commonly provided is that another piece of information that must also be provided is written notice that the person is classified as exempt from the overtime provisions of the FLSA. And next slide, in addition, there must be written notice that a person is classified as an independent contractor, and that must be provided before the person provides work under the contract. My takeaway from all of this is, of course, the agencies are, as you may be aware, very sensitive to who is exempt and who is not exempt, who is classified as an independent contractor, and whether that classification is correct or not. So this is arguably a way for the agencies to focus on that. The takeaway that I would suggest is that this paycheck transparency information, much of it may be provided already on employees' pay stubs, but it would be a fairly easy fix for contractors and subcontractors to work with their payroll providers now to make sure that everyone's pay stub contains any kind of missing information. Then there's not a debate about is this person working on the contract or not working on the contract. And why I suggest that is that this requirement will become effective on January 1, 2017. So very quickly, this requirement must be taken, will go into effect, and will require that this, quote, paycheck transparency should be complied with. Now, we don't know exactly how this to make a contractor more improve their business ethics or reliability, but it is part of the executive order and part of the guidance. Mayor Tony?
Thanks, Kim. I'm going to talk a little bit about the prohibition on the use of arbitration agreements. So, as a general matter, many employers prefer to arbitrate employee disputes. There are some benefits of arbitration, which include potential cost savings, the fact that you can have employees waive class claims, as well as confidentiality. Now, historically, the prohibition on entering into arbitration agreements has been limited to defense contractors. But here, the rule provides that contractors who have contracts for goods and services worth more than $1 million are prohibited from agreeing with employees in advance to arbitrate claims arising under a specific category of claims, which are under Title VII, as well as all tort claims related to sexual assault or harassment. Now, there are 3 exceptions to this rule. The first is if the employees are covered by a collective bargaining agreement that the contractor negotiated with a labor organization. The second is if the arbitration agreements were signed before the contractor or subcontractor became covered by the proposed rule. And the third exception is contractors who are providing commercial items or commercially available off-the-shelf items, which are commonly referred to as COTS. Now, if you prefer to arbitrate, you may want to consider seeking from an employee with a dispute his or her voluntary agreement to engage in arbitration after the dispute arose. So this is an avenue that an employer can pursue if they still want to go through arbitration with an employee. Now, of course, at this point, the control is in the employee, and the employee might not voluntarily agree to such an arrangement. So with that, I'm going to pass it back to Cameron to discuss best practices.
Thanks. I note that it's 2:07 and we're quickly running out of time, but I want to, as fast as I can, address at least two questions we've received. Can we go back to slide 17, please? One question is, when do the disclosure requirements kick in? Well, they kick in at the prime contractor level in 1 week, October 25, for solicitations estimated to be $50 million or more, which is a pretty large contract. That lasts until April 24 of next year, when it drops dramatically down to the threshold in the executive order of $500,000. For subcontractors, you get a full year from October 25 of this year. The requirements do not apply until October 25, 2017. And speaking of subcontractors, we got a question about clarifying who is a subcontractor for purposes of this new reg. Does it refer only to subs under identified prime contracts or a vendor generally supporting a contractor's business? And I think it's safe to say it applies to the former. It would not apply to, for example, the utility company supplying power to your plant. But if you've got someone who is awarded a subcontract by a prime contractor to perform a portion of the prime contract, and it exceeds $500,000 and is not for COTS items, that's going to be a covered subcontract. We have one other question that we may or may not be able to get to, but we wanted to throw in, if we can go to slide 33, some final practical best practices pointers. First, government commentary accompanying the new rule, as well as the guidance, states that contractors and subcontractors can work with the Department of Labor as part of an early engagement pre-assessment process to get compliance assistance if the contractor thinks that it's got covered labor law violations that it believes may be serious, repeated, willful, and/or pervasive. This is, we believe, an important step that people can take. There does not have to be an active solicitation out there for you to approach the Department of Labor. This is set forth in Section 6 of the guidance. In slide 34, establishes sort of an affirmative assessment from the Department of Labor under this pre-assessment guidance will give you clearance at the contracting officer level unless you've reported labor law violations after the meeting with the Department of Labor. In the next slide, ALCAs encourage prospective contractors that have labor law violations that may be serious, repeated, willful, or pervasive to go to the enforcement agencies to discuss and address those violations as soon as practicable. That may be more of a strategic decision by the contractor or subcontractor whether they want to go to the enforcement agency, which may then say, well, we need a labor compliance agreement, but we definitely think that the Department of Labor pre-assessment engagement process is a very valuable process. David, do you want to add some more best practices?
Yeah, there's a couple points on tracking and compliance. First, on tracking, three main considerations here. First, what needs to be tracked? I think obviously the labor law violations, the 14 federal laws, the equivalent state laws yet to be identified need to be tracked. When does that need to happen? Obviously before the first time that a submission is made in response to these requirements, and then semi-annually, every 6 months. I'll note that particularly with regard to mitigation measures, the contractor does not want to rest on that 6 months. The risk that I see there is that the contracting officer looks at a stale file that misses out on possible later mitigation measures that might have come into play, or remedial measures. Finally, who needs to do the tracking? This rule as a whole requires an integrated approach in terms of responding to the labor law violations. You've got a nexus, if you will, of HR and legal that may be particularly familiar with what the labor law violations are. You need to integrate the purchasing or supply chain management team that's looking downstream in terms of what subcontractors are providing. And finally, the business development folks. Business development teams or capture teams need to understand that the pursuit of each and every contract is going to be impacted, if it's assuming it's above the threshold, by the responsibility questions here, and there's a risk that contracting officers could reach different positions with regard to different contracts. Finally, on compliance, the rule contemplates that contractors may, though it doesn't require it, contemplates that contractors may need to develop IT systems to help track these labor law violations. That seems perfectly accurate to us. Purchasing systems, again, back to that supply chain management reference I made. A contractor needs to be able to show that it has a documented process for reviewing the responsibility of its subcontractors at all tiers. That is not currently enforced under the existing responsibility rules. I expect it will be going forward, particularly on the defense side, but also on other aspects, including GSA contracting. Finally, training. Because the rule is sweeping in its scope and it's different in a lot of respects than most government contract compliance requirements, the people who need to be trained on compliance is broader than you would normally expect. It includes the HR folks, it includes IT folks, it includes people who respond to proposals. They need to be aware of what the requirements are. They need to be aware of the need for current, accurate, and complete data, and maybe even better than current, accurate, and complete, meaning better than every 6 months being updated. And finally, they need to have an understanding as to what the ramifications of an adverse finding could be, a labor law violation could be with regard to the company business generally. Just briefly on litigation, I'll just make 2 points here. Both in the area of responsibility and in past performance, bid protests in those areas have generally been hard to win. The reason why they've been hard to win is that both for responsibility and in past performance, agencies have enjoyed tremendous deference in regard to judgments that they make as to whether a contractor is considered to be responsible or whether past performance is considered to be problematic. The change I see in both areas with regard to this new rule is that for both areas, the agency is now required to consider particular information, and protests regarding a failure to consider information have tended to do better in both the responsibility area and in the past performance area. So I see an increased risk for successful bid protests here. One final point is that the rule contemplates that in the past performance area, the adequacy or the efficacy with which regard to a prime contractor has addressed its own subcontractors' responsibility issues is fair game for a past performance review. I imagine it'll be fair game in a bid protest as well. Cameron?
And finally, in addition to a likely increase in bid protests, we think that the new rule will, in all likelihood, result in other types of litigation. I listed 3 types there. Let me just comment briefly on the prime subcontractor area. Because of the unprecedented new obligations imposed on primes with respect to subcontractor responsibility determinations, including this rather strange situation where you have to resolve a situation where a subcontractor disagrees with the Department of Labor, create fertile grounds for disputes between primes and subcontractors. So prime contractors should take these obligations seriously and perform careful and well-documented responsibility determinations. And I mentioned at the outset that the fact that a lot of new information has to be submitted to the government with associated obligations creates risk that the Department of Justice or a private whistleblower may use the new rules to bring allegations under the Civil False Claims Act, which packs a powerful wallop, penalties for each false claim, and treble damages. So, as always, contractors should be very careful to ensure that information provided to the government is accurate and complete. We received one other question, and it's a very good question about whether the information contractors submit can be obtained under FOIA. And I recall looking at this earlier when the rule first came out, and I believe there is some reference in the commentary preceding the FAR rule, but I'd like to double check that, and we'll get back to you with a response if that's acceptable. And yes, we will email the slides out, and I think a recording is, yeah. You'll get both the slides and the recording, and I'm going to pause now and give anyone a chance to type in any other questions that you may have. We'll wait just a minute for that. Okay, well, we certainly appreciate you joining us for today's call. We hope the information we shared was useful. If you have any questions related to this topic, please email them to Pascal Rucker at, Pascal, is your email up there? It is at the top on slide 41, and your questions will be forwarded promptly to the speakers. Thank you again for your participation, and have a great day.